jobs, we work every day with protected health information. And imagine that working in this job that we have, that you find out that a famous football player or a celebrity or even your family member goes into one of the hospitals that we work with. And you get so curious that you want to snoop around into the medical records and take a peek. And you might think, well, it's just looking, it might not be a big deal because I'm not really doing anything for this person. I'm not going to use their information for anything bad. But the truth is that just looking at a medical record for something you don't have a valid authorization, or if you don't have a valid reason, it is a HIPAA violation, and it could have very serious consequences, including jail time and fines. As you all know, HIPAA it stands for the Health Insurance Portability and Accountability Act, and this was implemented in 1996 by Congress. And among other things, it's basically a privacy law for health information. Of course, this applies directly to the job that we do. That's why our managers and supervisors are always telling us, do not do any inadvertent disclosure. Please watch what you do when you send records out. And you might think, well, this might be bad because I might get a write-up, or I might lose my job, or maybe I'll cause a problem for the company. But the truth is that it could have very serious consequences beyond that. Now, my speech today is going to be about real-life criminal cases for HIPAA violations, the outcome of those cases, and also some recent law changes that have made it even worse for the HIPAA violators. The first person that was criminally prosecuted for HIPAA violation was an employee of the Seattle Cancer Alliance. And according to a newsletter from August 2004 from Crowell Mooring, which is an international law firm, this person stole a cancer patient's medical records, not the medical records, but their information, and used it to open credit card accounts in the patient's name. Then he went ahead and he used those credit card accounts to buy video games and jewelry and clothes. The person was found guilty. He was sentenced to 10 to 16 months in prison, and he had to pay back all the money that he stole to the credit card companies and to the patient. Now, after that, the first HIPAA case that actually went to trial happened really close to us. This happened in 2007, and according to an article in Naples News from May 2007, it involved one of the employees from the Cleveland Clinic in Weston. This person had access to medical records, and she stole the records of 1,100 patients, the information, and sold it to her cousin in Naples who had a clinic. He used that information then to file fraudulent claims with Medicare for close to $3 million. Now, the Cleveland Clinic employee, she pled guilty, and she was sentenced to 3 years probation, including 6 months of home confinement, and she had to pay back $2.5 million in restitution. She testified against her cousin, and he was sentenced to 7 years in prison, and he also had to pay back $2.5 million. Now, looking at those cases, you might think, well, obviously those are criminal cases because they had malicious intent, they stole the information, and they used it for their personal gain. But not every HIPAA criminal case was that way. The next case, which was reported by the Journal of American Health Information Management Association, or HIMA, on April 2010, is about a researcher from the UCLA School of Medicine, and he was told that he was going to be dismissed from his job. Then, in the time before he was dismissed, he still had access to medical records, and he went in and accessed all the records for his supervisor, co-workers, and even some celebrities like Leonardo DiCaprio and Drew Barrymore. This person was sentenced to 4 months in prison, and he had to pay $2,000 in fine. Now, this is important because this person didn't do anything with that information. He just looked at the records. So that's significant. He didn't sell the information. All he did was look at the records. Now, to make matters worse, in 2009, the HITECH Act was implemented. HITECH stands for Health Information Technology for Economic and Clinical Health. And there were 2 significant changes in that act. One of them is that the fines were increased to a maximum of $1.5 million. And the next is that it gave authority to the state attorney general to file civil actions against HIPAA violators, which what that means is that now you could be sued if you have a HIPAA violation, or if you're the person creating a HIPAA violation. One of the first cases after the HITECH Act was implemented involved CVS pharmacies. As indicated by the website of the Department of Health and Human Services, CVS pharmacies started being investigated by the Federal Trade Commission, and the reason was because they were throwing away pill bottles that still have patient information in open containers in the trash. They had to pay a settlement of $2.5 million and implement procedures to make sure that those things don't happen in the future. Now that we have reviewed examples of criminal cases and you know how the punishment, how severe the punishment could be, keep in mind that the Department of Health and Human Services is the entity that investigates complaints, and they're very serious about punishment. They have allocated money and resources to investigation and audits, and their sanctions have become greater and greater in time. So next time that you put a record in a bin to send to a medical facility, or that you release records to a law firm, please remember to keep all the HIPAA guidelines in mind and consider that your actions could be very severe for yourself and the company that we work for. Thank you.